I'd like to thank all of you for coming out and joining us on this absolutely beautiful, beautiful Friday here in Washington in the fall. And I know all of you are very busy. My name is Robert Coulter, and I have the pleasure of helping Bill. I'm the Executive Vice President of Good Government Now, which Bill has founded, and as our president, I'm going to be introducing him shortly. And I just want to, again, thank all of you for coming out today on our session on inherent enforcement. And this follows it was about 3 or 4 weeks ago on civil enforcement of subpoenas. So it's great to see so many of you that are here for the second time, and that's just wonderful. So we'll get right down to it, and it's my pleasure to introduce Bill Murphy, our founder of Good Government Now.
Thank you, Rob, and thank you everyone for being here. Really pleased to see you. We've got another fabulous panel to talk about a very important topic. Our question is, can a revised inherent contempt procedure strengthen enforcement of House subpoenas to the executive branch? Our panelists will be discussing a proposal by Morton Rosenberg to revise the traditional inherent contempt procedure to address the challenges of the current environment. Our first panelist will be Stan Brand, who's going to lead off by explaining to us the history and background of how we have arrived where we have at the current crisis in oversight, effectiveness, and subpoena enforcement authority of the House. Stan, as we all know, is a senior counsel at Aiken Gump. He's not only a former U.S. House General Counsel, but was the first House General Counsel appointed by Tip O'Neill. Stan also is Vice President of Minor League Baseball, and he's also the Distinguished Fellow in Law and Government at Penn State's University Dickinson School of Law. After Stan speaks, we're going to hear from Liz Hempowicz from POGO. Liz is the Director of Public Policy at POGO, where she oversees POGO's legislative reform work with a focus on whistleblower protections and government accountability. She develops various policies to combat corruption and promote openness and accountability in government. Liz is a recent graduate of American University's Washington College of Law. And then, of course, we will hear from Mort Rosenberg. Mort really needs no introduction. He was a senior specialist in American public law with the American Law Division at the Congressional Research Service for 35 years. He currently serves as a senior fellow at Good Government Now, as well as the Constitution Fellow with the Constitution Project. He is the author, of course, of our inherent contempt procedure rule for the House. So with that, I will turn it over to Stan Brand. Stan, thank you.
Thanks, Bill. Bill mentioned my affiliation with professional baseball. So we're heavily into the World Series preamble now. So I'll say that think of me as what used to be known as the setup man. Those don't exist in baseball anymore, but they used to be important. And also one shout out to Irv Nathan, who was one of my very esteemed and distinguished successors in the office of General Counsel. Historical footnote, the office actually, when I took over in 1976, was General Counsel to the Clerk of the House. And when Tip O'Neill approached me to take the job and told me to check it out with the incumbent, I did. And I ran into O'Neill at a fundraiser a couple of weeks later, and he called me up to the dais. Now, remember that I'm 26 years old at this point. And he said to me, did you check out that job? And I said, well, you know, Mr. O'Neill, you've been my mentor, and I don't want to sound ungrateful, but the guy writes contracts for desks. And he was a cigar smoker. In those days, you could smoke cigars in public. And he leaned back and he looked up and he says, well, that's what that guy does. So 7 years later, I'd been in the Supreme Court twice and in 9 different courts of appeals, and so Tip O'Neill was right. My role as maybe the oldest person here, I don't know, maybe Mort beats me by a couple of months, is to assume the Homeric role of orally transmitting to you the history of congressional contempt and why we're in the position to be discussing what we're discussing today, which is the difficulty and obstacles to the House of Representatives getting resolution of disputes over subpoenas resolved in any timely fashion. And it goes back to a case in 1983 involving Ann Gorsuch, who was head of the Environmental Protection Agency. Yes, that Gorsuch, the mother of the new Associate Justice of the Supreme Court. She came to Washington in the Reagan years as administrator of the EPA and quickly got into a fight with several House committees over records that the House committees had subpoenaed involving CERCLA and RCRA, two statutes governing the reclamation of Superfund sites. And a very acrimonious dispute developed over documents, ultimately resulting in her being held in contempt by the full House. I think at the time, perhaps the highest ranking executive official ever held in contempt under the statute, the Congressional Contempt Statute, passed in 1857 to delegate to federal courts essentially the responsibility to adjudicate these claims. Just to explain how long ago this was in terms of modern history, the vote was overwhelmingly bipartisan. The Republicans joined into, I guess about 70 or 80 Republicans joined in voting for the congressional contempt, led by a man named Henry Hyde, who later became chairman of the House Judiciary Committee. So it was a different era when congressional oversight was seen as an institutional prerogative of the body, not so much a political battle. The contempt was voted, and the resolution was certified to the United States Attorney for the District of Columbia, which is the statutory scheme, contrary to the statute, which says that it shall be presented, and we'll leave aside the issue about whether shall means shall for this purpose. The U.S. Attorney determined not to present it to the grand jury, but under instructions from the Department of Justice, instead, virtually simultaneously with the vote on the floor, filed a civil lawsuit against the House, claiming that the contempt was unconstitutional, that it impinged on the prerogatives of the president, that it was an unseemly way to resolve these disputes, and we began to litigate that case. The case, everyone at the time told me, well, this is going to be a landmark case that's going to go to the Supreme Court. And I said, no, it's really like the pro se complaints that are filed by people at St. Elizabeth's. It's going to go the way of all flesh, and no one is going to have the chutzpah to appeal it to any higher court because no higher court would endorse such a theory, which is in fact what happened. Now, what happened after the case was dismissed was that the pressure on the administration to settle the dispute over the records of various committees overwhelmed them. And they dispatched the Deputy Attorney General and somebody from the White House to negotiate with the committee and come up with a resolution over the subpoena, which occurred. There is still a case in the case books that some of you may be familiar with called, ironically, United States versus House of Representatives. Now, I've always had trouble getting my head around that because the United States to me implies the sovereign, which clearly the department wasn't vindicating when it sued the House of Representatives. It was vindicating the interests at most of the executive branch. But again, I don't want to get too much into my professorial mode. What happened after that case, though, was somewhat of a sea change within the Department of Justice, where the department started to take the position that it would never, ever enforce the criminal contempt statute against executive branch officials who had been ordered to assert executive privilege. And so that began a process of frustration and atrophy for the Congress. Now, ironically, when the Justice Department filed the lawsuit against the House, I took the position on behalf of the House that there was no federal jurisdiction to decide such a civil lawsuit, that it was barred by the speech or debate clause, that it was barred by doctrines of standing, that it was barred by all kinds of other arguments, and it was an inappropriate attempt to frustrate and substitute for the orderly and approved means, which was the statute. By the way, one of the things I pointed out, and which is still true today, while the department asserted that the statute was an inappropriate use of the power of the House to criminalize disputes over documents, the department had previously used the statute itself to craft lesser included offenses to perjury when it wanted to accept guilty pleas from executive branch officials who lied to Congress. No less luminaries than, now, and these are all ancient history terms for you because you were all born long after this. Richard Helms, the head of the CIA, who pled guilty to a misdemeanor count of contempt of Congress for lying to the committee during the Watergate process. Richard Kleindienst, the Attorney General who resigned and was subsequently indicted and convicted under the congressional contempt statute. So while the department maintained the self-serving position that it could use the statute as it chose for its own purposes in those cases, it denied to Congress the ability to use that statute. By the way, as a baseball footnote, Manny Tejada, the former shortstop for the Baltimore Orioles, also pled guilty to the lesser included offense of contempt of Congress when he lied to congressional investigators during the baseball steroids investigation in an interview with the House Oversight Committee staff. So it's been used by the department. As I say, there was no appeal, and what began to happen in the Department of Justice was the institutionalization of this notion that the statute was an inappropriate vehicle, and that somehow the notion of prosecutorial discretion gave the department a reason for not enforcing the statute. Now, the notion of prosecutorial discretion is old and legitimate. It was our contention in the lawsuit, and would be to this day, that that was not an exercise of discretion. It was an abuse of discretion, because none of the traditional rationales for prosecutorial discretion, staleness of the case, lack of evidence, on and on and on, were present in the Gorsuch case. In fact, presentation of a case to the grand jury under 2 U.S.C. 192 is a very simple matter. It's not a complicated case. As I said a couple of weeks ago, even a caveman could present that case to the grand jury. But it wasn't presented, and the department took this position, and it began to solidify within the department to the extent that even Democratic justice departments began to pietistically intone the same arguments that had been floated by the Reagan administration. And so we come to the point now where the House's ability to enforce subpoenas under the statute has been stopped. The House has used alternative means. The House itself took a page from the Justice Department book and brought a civil case, successfully, I might add, against Harriet Miers during the Bush administration when the Judiciary Committee investigated the firing of U.S. attorneys. And the Republican committee successfully, brought a lawsuit against Eric Holder in the Fast and Furious situation. Now, one of the problems with that, and my colleagues will get into this more, that's a one-way trip to obscurity, because it takes 3 years to litigate these cases, even in the district court. And by that time, sometimes the Congress has expired, the Congress that was interested in the information, sometimes people have left. So it's not a speedy and efficient way to resolve these disputes. And judges, for their part, district court judges aren't really happy to get these cases. They don't want to decide nerve center disputes between the political branches. They shy away from that for all kinds of reasons. And so they're not particularly amenable to mediating these on behalf of the branches. The last thing I'll say is that I think the impact of the Gorsuch case and the trail that it's left thereafter has even leached into non-governmental enforcement cases. And I have in mind here a case recently, which some of you may remember, which was the House investigation of the Internal Revenue Service's handling of tax-exempt applications by charitable organizations. And Lois Lerner, who was held in contempt of the House and sent over to the U.S. Attorney for prosecution, and who had asserted her Fifth Amendment claims in front of the committee, but not before giving an introductory statement, which the committee majority claimed was a waiver of her Fifth Amendment rights. Nevertheless, they sent her to the U.S. Attorney. Now, in the very old days, pre-Gorsuch, in the 50s and 60s, when the House Un-American Activities and their confreres were putting everybody and their brother into contempt, the U.S. attorneys would basically pro forma put all those cases in front of the grand jury. And if you had a complaint about the process, whether that was a violation of a House rule or the Fifth Amendment, tell it to the judge. We're going to bring the case and let the court sort it out. Well, in the Lois Lerner case, the Justice Department, through the U.S. Attorney, decided sua sponte, we're not going to present the case. We're not going to present the case because we have reviewed the claim of waiver, and we don't believe that any reasonable attorney could take the position that she's waived the claim, and so we're not even going to present it. So my contention would be that this isn't even now limited just to governmental disputes. It has leached over into private disputes, and lawyers who are reading this, representing witnesses in front of the Congress, are, like me now, are encouraged to test the limits of the power of the Congress, because it looks as if the department is really not committed to enforcing the criminal contempt statute. And so that has brought us to the current moment where, as we look at the power of the Congress to conduct oversight and conduct appropriate inquiries into the administration of the statutes that Congress has passed, is stymied in a way, which leads us to the Rosenberg proposal. And that's the historical gloss. You can, as Doug Harvey, the umpire, used to say, you can look all this up. It's in the books. Again, as a historical note, the House did put someone in contempt in the EPA scandal, and that was a woman named Rita Lavelle. That was the last time, that was 1983, that was the last time anyone has faced trial under the congressional criminal contempt statute. That's 1983. So you can see that the process and the power has atrophied a good deal in that time. So with that, I'll pass it on to the next speaker. Thank you. Oh, and by the way, for anyone who can't sleep at night, there's a Law Review article that I wrote in 1983, which is still, or 1984, which is still current in terms of the history of the Gorsuch case and what it means today. It's in the Catholic University Law Review, volume 36. Thank you.
I thought I was the only one who brought a prop, but I guess I'm not. Thank you so much, Stan, for that helpful explanation of how we got to where we are today. And thank you, Bill, for putting this panel together. I'm excited to be here representing the Project on Government Oversight. If you're not familiar with our work, our name says it all. We're committed to oversight, and we see working on increasing and preserving Congress's ability to conduct oversight, rigorous oversight over the executive branch as central to our mission. In fact, our monthly congressional training program, which is aimed at educating staffers on current authorities, is happening right now at the Capitol Visitor Center. I'll admit that when I first saw Mort's proposed rule, I wasn't entirely sure it was necessary, and I wish I had just called Stan before doing my own research on this. He said if you wanted to look it up, all the information's out there. There's a great CRS report, but it's a little drier than Stan's presentation was. So after I did my homework, I'm now convinced that Congress has to reform its inherent contempt procedures to preserve its access to executive branch information. Congress has the right to information necessary to carry out its oversight and legislative functions, and that seems kind of not necessary to be said, but it does have the right to that information, and Congress should be demanding it. Congress's oversight duties are essential to creating an accountable federal government and upholding our democracy's systems of checks and balances. However, and this will likely not come as a surprise to many of you in the room, those that are subject to oversight are often pretty resistant to it. My favorite and also my least favorite example of this is the growing practice of executive branch officials sending documents in response to congressional requests that have been subject to FOIA redactions. FOIA is the Freedom of Information Act. It's what people like me can use to get information out of the government. And I don't think it really needs saying that members of Congress should have a little bit more information about what's going on in the government than I do. And I say that as a member of a watchdog organization, so just take that as you will. That's why it's imperative that Congress have the ability and option to enforce its subpoenas unilaterally. Stan did a really good job of laying out the important historical context for this conversation, and I think Mort's inherent contempt proposal does a really good job of threading the needle created by the various case law and history of congressional contempt procedures. In Pogo's Handbook for Staffers, here's my prop, The Art of Congressional Oversight, a user's guide to doing it right, we write that the threat of a congressional subpoena is often enough to compel the executive branch to cooperate with your inquiries. But that's only true to the extent that a congressional subpoena is a real threat. There's an inherent tension that Stan definitely touched on when Congress has to rely on the discretion of the Department of Justice to enforce its attempts to get information from the executive branch, of which the Department of Justice is a part. Thank you. And civil enforcement through the judicial branch has its own limitations. This proposal won't do away with any of those other avenues to enforce a subpoena, but it will provide an alternative when necessary. My one concern with Mort's proposal isn't related to the proposal at all, but rather the current climate of oversight in Congress and the possibility that bad faith actors could use this process to further the partisan divide. While there have been some good bipartisan moments in the last 2 years, for example, Senators Grassley and Blumenthal working together to examine how government employees receive approval to access sensitive or classified information, look up their work on it, it's really interesting. There are also countless examples of partisan oversight in areas where bipartisanship used to be the norm. It seems increasingly rare that lawmakers can reach across the aisle to cooperate and conduct oversight together, even on matters of bipartisan concern. Bipartisan oversight remains the most effective form of congressional oversight, with the greatest likelihood of securing answers, driving reform, and checking the executive branch and its overreach. Much of my work over the last few years has focused on reforms to whistleblower protections, the Freedom of Information Act, and the offices of the Inspector General. All three areas have benefited from rigorous bipartisan oversight that led to legislative reforms in this and the previous Congress. Mort's proposal intentionally brings the minority into the inherent contempt process by allowing the minority leader to appoint 2 members of the 5-member select committee. And he's going to go into it in a little bit more detail, so I won't try to explain his words better than he can. While rules can't force bipartisan cooperation, they can be written in ways that makes that cooperation possible, and I think this is a wise inclusion for this proposal. I'm excited to be a part of this conversation today and look forward to further discussion during the question and answer. But if I can leave you with one takeaway, it would be that subpoena power is one of the strongest tools Congress has to fulfill its mission, and a change is necessary to re-empower Congress to use this tool without the aid of another executive branch, or without another branch of government. Thank you.
I'm a little bit shorter than these. Welcome, and I want to thank Bill Murphy for being so instrumental and so vigorous in putting this together and being a force behind trying to explain what the problems are. Most of you are too young to remember me, but I was known as apparently as an institutional zealot, and that's true. And I'm going to demonstrate that now in what I'm going to tell you. The problem we are addressing today is not a simple political problem that can be resolved by electing a new House majority that will control and institute oversight and investigative proceedings that will reveal what is actually going on in executive branch agencies and departments and the White House. Recent media articles and commentary have been replete with speculation and anticipation about the flood tide of subpoenas that will be issued by a new majority and the topics of executive branch policies, actions, and inactions that will be the targets of such compulsory demands. All of them have avoided mentioning the 800-pound gorilla that is in the room. None of them have broached the question, the critical question, that has arisen whether congressional committees presently have the legal authority to effectively enforce testimonial or documentary subpoenas against executive officials, or even the will to ensure that it will take the measures that will make it effective. Over the last decade, the executive has successfully obstructed Congress's investigative capabilities. It has accomplished this contrary to the long-recognized legal and practical understanding that Congress, acting as a body or through its committees, has the virtually absolute constitutional power and responsibility to make and enforce information access demands to the executive branch that it deems necessary to enforce information to accomplish its legislative duties. It has ignored established congressional rules, tools, and support mechanisms that identify, analyze, and effectively utilize such sought-after information, and that allow committees to make the initial determination whether there is an overriding need for the sought-after information. The Justice Department, instead, has instituted and executed a thus far uncontested strategy of compelling committees to seek judicial assistance in order to gain compliance with their document and testimonial subpoenas by civil court proceedings. It has done this by declaring that Congress is a resort to its historic, constitutionally recognized self-protective mechanisms of inherent and criminal contempt. Proceedings are unconstitutional. The demonstrable consequence of this stratagem has been the crippling of the legislature's information gathering authority and thereby the undermining of its core constitutionally mandated legislative function. It has done this by shifting the burden historically placed on a recalcitrant executive official to defend against a charge of inherent or criminal contempt to a committee. And that committee must now seek judicial assistance to obtain compliance. As Stan has pointed out, litigation takes time and risks aberrant judicial rulings, both of which have occurred. And Stan has underestimated the second suit, the Fast and Furious suit. That suit has been going on for 7.5 years, is currently before a court of appeals, has been for about a year or so. A settlement has been attempted by the House General Counsel's office, and part of the settlement was that the judge's rulings in the case, in two opinions, should be vacated. Well, it's been before that judge now for about 6 months and has not been resolved. And It's just part of the delay mechanism. 7.5 years has made, the question that was raised in Fast and Furious moot. But the consequence of it has been to affect it has affected how agencies respond to subpoenas. Indeed, the uncertainty of whether committees can impose timely, meaningful consequences for delays or outright refusals to comply with legitimate information demands has fostered an environment of agency slow walking and encouraged the assertion of dilatory, non-constitutional privileges. The failure to challenge such blatant executive usurpations of congressional prerogatives reflects an abnegation of institutional integrity and will. While Congress cannot expressly abdicate its core constitutional responsibilities by inaction or acquiescence, it can be effectively ceded elsewhere. That, to me, is intolerable. I would categorize this situation as a true constitutional crisis that must be addressed immediately and aggressively. What can and should be done? In my 35 years as a senior legal analyst at CRS, specializing in questions about separation of powers and investigative oversight, and in the last 10 years of so-called retirement, I've been mulling about these experiences, and I've concluded that despite the Supreme Court's consistent recognition of the breadth of Congress's authority to access information about executive activities, the enduring lesson of successful past oversight inquiries is that committees must establish their credibility with the White House and the executive departments and agencies they wish to oversee early, often, and consistently, and in a manner evoking respect, if not fear. Thus, while standing and special committees have been vested with a formidable array of rules and tools to support their powers of inquiry, and have developed over time a very efficacious, nuanced, staged investigatory process, that is, one that proceeds from one level of persuasion or pressure to the next to achieve some mutually acceptable basis of accommodation with the executive. What has been absolutely critical for the success of those endeavors was that there was a credible threat of meaningful consequences for refusals to provide necessary information in a timely manner. For over 200 years, that threat has been the possibility of a citation of inherent contempt before the bar of the Houses of Congress, and that prevailed between 1795 to 1935, or criminal prosecutions for contempt of Congress, which was established in 1857 and effectively worked until my experience in 2002. And all those could resulted in incarceration or fines, which had been consistently successful in inducing executive branch officials to comply even before the commencement of such formal proceedings. Between 1975 and 1998, 10 such instances of compliance by executive officials before trials occurred, many of which I was involved in. Essentially, the common factor in each one was the reluctance of the subject contemnor to subject him or herself to a criminal prosecution just for the sake of establishing a principle of constitutional or common law privilege for the president. The case of Anne Gorsuch Burford, which Stan commented about, is a clear case in point. If you read her biography, you'll see that she was gulled into being, a symbol or, a vehicle for establishing the notion that Congress could not bring criminal contempt proceedings against an executive official. And she was guaranteed that she would be represented by the government and that she would never have to go to trial. Well, when Stan got it kicked out, the trial became imminent. She quit. 20 other people were, either quit or retired at the EPA, and the case was settled, almost settled. The initial settlement was deemed so vague and unproductive by John Dingell that he stood up and he said, I refuse to, be influenced by that, and I won't be bound by it. And if we don't get all the documents that were necessary, I'm going to enforce another subpoena and have another contempt proceeding. And the White House caved completely after that. Those criminal contempt proceedings, as I said, were effective up until 1998, and there were 10 of them. So, what form should the challenges take in order to restore Congress's ability to enforce its subpoenas? Well, one would be a revival of the independent counsel model with appropriate modifications for control over perceived flaws in the original statute. That route, however, is unlikely to be signed into law by any president, and particularly this president. More appropriate would be for the House to exercise its rulemaking authority to establish what I've called a seemly inherent contempt procedure. Historically, the inherent contempt process was very successful and was actually used against two sitting officials. The threat of arrest, detention, incarceration was formidable, and its constitutionality and its necessity as an institutional self-protective mechanism was recognized by the Supreme Court at least 4 times, the first time in 1821. Indeed, the Supreme Court's ruling in McGrain versus Doherty in 1927, which established the modern-day breadth and legitimacy of Congress's investigative authority, was the result of an inherent contempt proceeding, respecting an investigation of maladministration at the Department of Justice. It has not been utilized since 1935 because it took too much floor time, often entailed a consuming habeas corpus proceeding, and its punishment of imprisonment was limited to the end of the session in which the contempt occurred. The alternative of criminal prosecutions avoided those burdens with similar success and has been used exclusively since 1935. In recent times, however, some courts and commentators have questioned its seeming draconian nature, but none have questioned its continued constitutionality or that it can be modified to conform to modern sensibilities and still be effective. I've attempted to design an alternative procedure that eliminates arrest, detention, and jail time and substitutes a speedier internal and institutional process that reflects due process and relies on hefty, incrementally increasing monetary fines as its coercive incentive. The 1821 Anderson case that I mentioned recognized the validity of congressional inherent contempt, strongly suggested that fines were permissible, analogizing the inherent self-protective powers of courts to impose fines as well as imprisonment. The rule that I propose essentially encapsulates the staged process of executive investigations, going from one stage to another to try to get a common process. So that doesn't change or put any kind of new obligations or new operational matters or limits, on the discretion of committees when they are engaged in investigations. But at some particular point, it has to stop, and the committee has to make a decision whether the refusal by a responsible official goes beyond the pale and undermines the institutional need for the kind of information. And at that particular point, I propose that the committee take a vote. If it votes for contempt, it makes a report about what the nature of the investigation is, what they've done, what the accommodations were proposed, and presents that report and to the speaker. And the speaker must then establish a special committee, a select committee composed of 5 members, 3 appointed by the speaker and 2 by the minority leader. This is a safety valve feature. We all know that sometimes committee chairs go a little bit wild. And this is, this particular feature is meant to provide for a relook. The establishment of such a special committee has been, blessed by the Supreme Court in a case called United States versus Nixon that dealt with the Senate's use of special committees to put together the facts and recommendations for floor consideration. This is what this select committee does. It will, helped by the House General Counsel's office, substantiate the necessity for a criminal contempt citation. And if it, presents a report at that particular point back to the speaker, either saying that there is a need for a contempt citation or no need. And if there is a need, there will be a recommendation for the fine. The fine can be, enforced by the House General Counsel, and when it goes to the floor, there can be a speedy process. Due process is provided for the alleged contemnor, and I think it will be a process that will take quite a bit less than 7.5 years, and less than the 2 years that it took for the Myers case, and is something that is important to be looked at. A third possibility is for the House to directly appoint a private sector attorney to prosecute a contemnor. The Supreme Court in the 1987 ruling, upheld the inherent authority of a district court judge to make such an appointment, pursuant to its inherent self-protective authority. That ruling and the dicta in the Anderson case were the basis of a Ninth Circuit ruling of a week ago, last Wednesday, that reiterated the inherent authority of the district court to appoint a special counsel. The long-standing judicial recognition of this analogous self-protective authority should give rise to consideration of such a prosecutorial appointment by House authorization upon a vote of criminal contempt citation by the House. There are plausible grounds for the success of such a remedy, and the Supreme Court has recognized the legitimacy of concurrent or seriatim inherent and criminal citations. There's a difference between inherent contempt and criminal contempt. Inherent contempt is the vehicle to get an immediate disclosure of the documents or the testimony, or get the testimony. Criminal contempt, on the other hand, is a punishment for the failure to do so. That was extraordinary. Both of those together provide the kind of leverage that the House needs to revive its subpoena enforcement authority. Thank you.
You okay? Okay, thank you very much to our excellent panelists. We'd like to now open the floor to questions. I'd ask if you have a question to please come up and use this podium. There's a microphone here at the front of the room, and that way we can pick up your questions and our panel responses on the audio. So
Oh, wow. So what have been the political obstacles to making this rule change? Why wasn't this a rule change that happened under Boehner or Paul Ryan? And has there been a discussion within Democratic leadership about making this rule change should they get in the majority in 2019?
Okay, thanks. I'll just be loud. There's been no consideration that I'm aware of in the past. What has happened with regard to the criminal contempt is that it's been utilized. It's been utilized by both parties when they were going after presidents and the other administrations in the other parties. So, with regard to criminal contempt and or at least doing it by going to court, both have agreed that going to court is a good idea if it's against the other party. There hasn't been serious consideration of my proposal of inherent contempt that I'm aware of. It may be going on now. I don't think that there is a sense that getting ahead of the curve of the election in November would be wise to present an effective kind of proposal that I am proposing.
If I can, put my amateur political hat on for a bit here, because this is more than a legal question and something that I confronted when I was counsel. You have to understand something. Congressional subpoenas and oversight, that's the stuff of lawyers. And I always used to go into Tip O'Neill and explain this to him. He'd get this blank stare on his face and concern about a chairman, embroiling the House in some type of nerve center constitutional crisis. And generally, the leadership on both sides of the aisle is seeking to avoid that. So these things are the esoterica of investigating committees and lawyers. They're not the grist of typical congressional activity. Even in this Congress, the typical congressional activity involves, budgets and authorizations and, subject matters that get people excited. Enforcing congressional subpoenas against executive officials doesn't excite them. Even if they are, hot on the trail of something they think is important. So this is hard stuff to get people to think, is a necessary priority in the overall scheme of what the House has to concern itself with day to day.
I would also just jump in to say I would caution both political parties from looking at this as something as subpoenas as something to use as a weapon and weaponized oversight. I think history shows us that leadership will go back and forth, and so even if you're wielding the power one day, you will be subject to it the next. And so I think this proposal needs to be considered from a few steps back of kind of the political reality, I think, for the most part. And on the merits, it institutionally shores up the Congress as a whole, not a Congress that's led by either party.
Thank you all for this very interesting and important presentation. Traditionally, the way that inherent contempt has worked is the body brings the witness who's recalcitrant before the bar of the House or Senate, and then if they decide that the witness is in contempt, the sergeant at arms takes that person and puts them in jail somewhere. And then that can be challenged through a habeas petition, right? In your proposal, how would one get from the body deciding that the witness is in contempt and fine should be imposed to actually either having a challenge to that determination, or if there's no challenge possible, how does the body actually collect the fines?
I would presume, well, first of all, there would be a trial, and there would be the opportunity during the select committee's consideration as to the utility and of it that will provide a substantial basis for the criminal contempt. There would be a trial on the floor, which the contemptor could be, questioned or have an attorney, by his side. It would be limited. Once it is the contemptor is convicted and the fine assessed, I presume that the House Counsel can demand and go and and enforce it. There would be an opportunity at that particular point. Well, just remember the initial case that this will be brought is going to go to the Supreme Court. But once that it's established, and I think it will be so established, the collection of the fine will be a perfunctory legal procedure. I don't understand.
Yeah, I mean, you have to execute on the judgment, but it would be a liquidated claim at that point. And, I mean, that in itself would seem to me to be an enforcement mechanism. I don't know how many agency officials want to go through that process. Once it's been established that there's a lawful right to what's being demanded. Yeah. You mentioned the Nixon case, which I assume you meant the Judge Nixon case.
Judge Nixon,
not
yes.
the President Nixon. Judge Nixon, who was impeached and went to trial in the Senate and actually represented himself on the floor and was able to question committee members. And so there was an actual proceeding on the floor of the Senate, which I assume would be somewhat similar to this.
Yes.
In the way that it worked.
That's the way the Senate is working now. They have a preliminary special committee set up to summarize what's going on, give recommendations, and to take to curtail the kind of trial that goes on in the Senate. Impeachment, of course, is a far more complex process invoking, both houses of Congress, in various ways. But the shortened process that I have, and the process that I have, I'm proposing, I think can work very effectively.
So I guess there's also the Treasury offset program. I would think that the House or the Senate could use the Treasury offset program to, just like you collect any other debt that's owed to the United States, you take it out of somebody's refund check from the IRS or from their Social Security check at some point or whatever. I have a question for Stan primarily on the initial premise of this whole thing as to why the presentment requirement can't work, or if there's a way to revise that short of this to make it work better. When Attorney General Holder was held in contempt by a bipartisan vote of the House, I believe the Deputy Attorney General announced before the citation had even been delivered that the U.S. Attorney, who has the requirement under the statute, had already analyzed it and made a decision that because there was an invocation of executive privilege that Therefore, he wasn't going to present it to the grand jury. My question is, and this I think is an evidence of how much behind the 8-ball Congress is. I'm confused, and I wish we had someone from the executive branch who could maybe answer this. I'm confused as to why they don't even fake it a little more, because all the statute requires is that you present it, right? I mean, if you want to exercise prosecutorial discretion, you could always dismiss it later if someone were indicted.
There's a whole complicated matrix of issues presented by that. First is, does shall mean shall in this case? Now, in most instances when Congress says shall, that's what it means. In fact, in the impoundment cases, when Nixon attempted to withhold congressional appropriations through impoundment, the courts found shall means shall, you have to spend the money. One of the things that the department raised in the Gorsuch case was this notion that you can't make a U.S. attorney sign an indictment if in his judgment it is not constitutional. And it goes back to actually the civil rights era in Cox versus Louisiana, where the grand jury indicted civil rights workers for very spurious violations of law. And the U.S. attorney said, I'm not signing this because this is clearly beyond the pale of what a grand juror has the authority to do. So you get into a very complicated matrix of issues. At one point in our case, somebody came to me and said, well, you should go file a mandamus action against the U.S. attorney and force him to present the matter to the grand jury. Well, you can't mandamus discretionary acts. You can mandamus a federal official where the duty has been reduced to a ministerial act. But presenting something to the grand jury is not a ministerial act. It requires some degree of legal, sophistication and scholarship. That was a question we had during the Gorsuch case. Why didn't the U.S. attorney just deep six the indictment in the grand jury, which he could have done? They had a position which they wanted to press. They had a theory that they had invented about why these things were beyond the pale, and they wanted to test that. And so they didn't go that route. I should tell you, we did torture the U.S. attorney over this. In fact, when the contempt passed on the House floor at 11 or 12 o'clock at night, the sergeant at arms was preparing to mail it to the U.S. attorney. I said, no, don't mail it. What I want you to do is go into a squad car and deliver it to his house in Bethesda right now. And that's what he did, to impress on the U.S. attorney that we were serious about this. This wasn't just some pro forma passage of, here, take this. This is an order. This will go in my book, of course. The U.S. attorney was a guy named Stan Harris, who happened to be the son of a Washington Senators baseball player, Bucky Harris. And Stan Harris came up to my office at one point after we served him, and he wanted to have a meeting with me. And I sent message out, I'm not talking to the U.S. attorney. We're in litigation, and he sued us. And the way he's going to hear from us is through the court. So, but back to your question, very, very difficult questions. To try to figure out a way to force the department to accept the interpretation that shall means shall. And one of the ways we tried was to expose their argument that it was prosecutorial discretion as a sham, that it wasn't really the exercise of traditional prosecutorial discretion as we know it, but rather sheer obstruction and refusal under any circumstances to bring such a case.
Well, I guess so. My point in terms of thinking of potential reforms, could you create some sort of a process that would require that, again, that they at least fake it, that they at least pretend that you give the statutory duty to the U.S. attorney to at least do an analysis. In the Holder case, there's no way that the U.S. attorney had reviewed the documents, looked at the issues, and made an independent determination, which it's his job to do under the statute. He wasn't exercising discretion. Right. He didn't have time to. Right. So can you think of a way that maybe you could create a process that require them to go through certain steps that would at least make them think about the issue?
Not off the top of my head, but I think that's worth looking at. I don't know what that procedure would be or how you would statutorily engraft that, but maybe Maybe there's a way.
Let me make a suggestion here. The case law dealing with inherent contempt has made it clear that inherent contempt, and this case that I mentioned that was decided a little over a week ago, the Arapaho case, reiterated that courts, in order to enforce their contempt rulings, can appoint prosecutors. And that analogy of the power of judges, district court judges, was analogized to the power of the Congress to do this. One thing that was recognized clearly in Morrison versus Olson was that 1987 case, Louis Vuitton, which was mentioned in Morrison versus Olson as an example of avoiding the obvious conflict of interest that the Justice Department has in bringing contempt citations against one of their clients, in effect, the judicial branch. That's why my last suggestion with regard to perhaps mimicking what was allowed in Louis Vuitton, and now more recently by the Ninth Circuit, which is allowing a judge to appoint an independent prosecutor, a private. I think that's possible, and would be an alternative or a companion to doing the inherent contempt rule.
Hi. Mort, first of all, I want to commend you for pursuing this issue, because it definitely is going to become an issue if the Democrats do take the House in the midterms, and we're likely to see a recalcitrant executive branch in responding to the subpoenas that are likely to be forthcoming. So I think it's a good idea. But I don't endorse your proposal for a variety of reasons. The first is there's an assumption in your proposal that the assertion of privilege is frivolous or unjustified, and that the Congress, including the House, can be the ultimate determiner of the issue of the privilege. If you say they've asserted privilege and we're going to fine you because we don't think the privilege applies, I don't think, first of all, under the scheme of the Constitution, that that's appropriate. There needs to be, if the fact is that we have co-equal branches in the Congress and the executive, there needs to be some independent arbiter, and that's what courts can do to resolve that issue. And that's what's happened in every kind of assertion of privilege, including executive privilege. Even when the executive was fighting itself, it had to go to the courts in the President Nixon case. So that's the first issue. And the second is that even the proposal, I agree with you with respect to inherent contempt and the ability to fine. There's no doubt that if you can incarcerate, which you can from the Anderson against Dunn case and later cases, that you could impose a fine. But that, too, is going to go to court, as you recognize, and is going to take a long time, even after it's resolved that there is this power, because every case is different, and you have to have an opportunity. Even if you were to incarcerate an executive branch official, you get to court because you go to habeas corpus, and you're still going to have the courts resolve it. So I don't think there's a real valid way. And let me say the one thing that Stan's history is not quite accurate it wasn't the executive branch that insisted that the House go to court. In fact, the executive branch argued that the House couldn't go to court and had many ways to, in the Myers case, to seek dismissal in the courts. And in fact, the Republicans, who were in the minority at the time, agreed with the Department of Justice and sought to get the case dismissed. It was our office at the General Counsel of the House that recognized, as you heard today, when you suggested that there could be an arrest and incarceration in the House, apart from the fact there's no jail and it's now the snack bar, and it would be cruel and unusual to put somebody in the snack bar for the rest of the congressional term, it was our office that determined that, first of all, we did seek to get criminal contempt, and the Attorney General said we're not going to pursue criminal contempt, which is clearly within their rights, because the person from the executive branch who is refusing to produce the documents or to testify is doing it at the instance of the executive branch. And so the notion that the people who are telling them not to comply are then going to prosecute them for not complying is fanciful. It's not going to happen.
But then how do they show up at the hearing representing the witness without incurring the conflict? I mean, that was the mischief of what they did in Gorsuch. And they were asked under oath, isn't it going to be a conflict for you later to vindicate this process under the statute, since you're the one giving Ann Gorsuch the legal advice as we sit here? And they said, oh, no, that's not a problem.
Well, look, maybe there's a conflict, but it's simply not going to happen that they're going to prosecute someone who is following their advice not to give the information over, whether to testify or to documents. But let me say this. I think there's a real problem here, and I think it needs a solution. I don't think it's going to be possible to exclude the courts from the resolution. And what I think, and it's also not accurate, by the way, that you described with respect to the delays. It's true as to the Fast and Furious case, but in the Harriet Myers case, we got a ruling within months of bringing the case. And even with the Gorsuch case, while you couldn't get criminal prosecution, and even the next threat of another criminal prosecution was meaningless, it was the public pressure. And so it seems to me that we have to find a way to get prompt court review of any such dispute, legislation or a court rule that requires expedited treatment of any case that's brought by the Congress against the executive branch, and that we have to find a way that puts pressure on the executive branch. And I don't think the fines are going to do it, because fines, first of all, if you have a fine, it's going to take court proceeding to collect the fine. But even apart from that, no individual is going to be subject to this fine. They're going to be reimbursed. They're going to be indemnified by the agency that has told them not to produce the documents or not to testify. So this is going to be the U.S. funds from the Treasury Department that are going to go back to the Treasury Department, and all it's going to mean is that the executive agency is not going to be able to carry out its functions as broadly as they otherwise could if the money is going to be deprived from the agency. So I think you need to find ways that the Congress puts political pressure on, including public opinion, which is, of course, what happened in Gorsuch, to say that. So I think there needs to be contempt. There needs to be an effort to coerce the executive branch to comply. There needs to be a judicial action that is as prompt as possible. And there needs to be the exercise of congressional power, including, obviously, the power of the purse, over the agencies and the executive branch in order to put public pressure on the executive branch to comply. So I would focus on those rules and pressures as opposed to this rule change, which I don't think would make much of a difference.
Okay. There's some presumptions that Irv makes that I disagree with. The first thing is congressional committees for centuries have been first determiners of the applicability and acceptability of privileges, and that has been appropriate. The burden was put, excuse me? Not ultimate, the first determiner. What the Justice Department is doing now is taking that away from them. They aren't the first determiner anymore. The determiner is the alleged contemnor who refuses, and then Congress has to go to a court. There have been lots of expedited judicial statutes that provide for expedited judicial review. And as far as I'm aware, they don't work. It'll still take years for these particular kinds of cases, especially when they're complex and have to have special masters looking at thousands of documents to determine, whether there is a legitimate claim or not. Also, your notion that we have co-equal branches, which somehow or another, give this authority and the burden, initial burden, on the committees to establish, the applicability of a privilege, simply isn't right. Co-equal doesn't mean that each one of them has a say and a veto power over it. Congress is the first branch. Congress has, the power of the purse, power to determine policy, power to get information about everything, and that's the key. They have the power and the responsibility, of acting, and it's not co-equal that a president interprets the duty to take care clause as a power to decide which laws apply. So that I just don't see where the inherent contempt process, which can be limited, by the way, one of the provisions is there can be no public funds utilized, to pay the fines, and they could pass a law that somebody who attempts to pay the fines from a private party, that could be made a contemptible offense also. But I think both of these proposals need to be considered and utilized in conjunction with each other.
Let me just respond briefly. With respect to being the initial determiner, I agree with you completely that the Congress has a responsibility to determine whether the privilege is properly invoked. And if you're being held in contempt, there's a resolution there that this is not an appropriate assertion of the privilege. But even if you were to have a fine situation and the contemnor goes to court, the court is going to review whether the privilege was properly asserted, whether this privilege was proper and appropriate, and if it was, then they're not going to uphold the fine. So ultimately, in any event that you choose, it is going to be the court that is going to be the final determiner of whether the privilege was properly asserted, just like it was in U.S. against Nixon, the presidential case. And with respect to where the money is going to come from, I don't think you can do that by a rule of the House. That would have to be congressional legislation, which is also the problem with my proposal with respect to expedited treatment, that it would have to be legislation and it would have to be passed by both houses, and if the other house doesn't change, that's not likely to happen, and there's probably not enough votes to override a veto that is likely to happen. So there's a serious problem here, and again, I come back to putting political pressure on the executive branch through publicity and the powers that you describe to coerce compliance with appropriately issued subpoenas.
I would just say my experience with expedition, and I see my colleague Andrew Herman in the audience nodding, who litigated the Davis case with me in the Supreme Court. The Federal Election Campaign Act had an expedited procedure provision, which we asserted in the three-judge court that ruled, and they just ignored us. And we showed it to them in our briefs, and they just didn't pay any attention to it. In fact, what they really did is aid and abetted mooting the case, because by the time we got the Supreme Court ruling, the election was over. And so the issue of whether Davis had, violated the Millionaires Amendment or not was at least no longer live from that standpoint. So the judicial acceptance of commands from Congress to expedite are not as foolproof. I guess the other point that I'd make is, of course, not every claim that the executive has involves a privilege claim. Sometimes they've got, confidentiality or trade secrets, or, they can come up with 100 different excuses. That's one of the problems. The other problem is, you're right, Irv, in the Gorsuch case, what ultimately forced compliance was public pressure, was the fact that every night on the nightly news, they would show these guys in moon suits cleaning up dioxin somewhere. And the pressure got politically too much for the administration to take, and they caved. They didn't cave because of a judicial order. But to get to that level of pressure, as you know, that can take a lot of time and a lot of work as well. And not every nitty-gritty oversight question, as important as it may be within the confines of that committee, is going to get to that level. So that's a hard road to hoe for Congress.
Do we have any other questions? Yes, sir. Sure, please.
All right, so I'll try to make my question brief. Do any of you have a fear that using a system where contempt is only enforced via fine would, number one, create a system in which, especially at high levels of the executive branch, where you do tend to get very wealthy people that are given political appointed positions, is there a fear that it would create a situation, number one, where wealthy individuals in the executive branch should be able to circumvent Congress by being able to afford the fines, whereas not wealthy people in executive positions would not? And number two, do you think that would then create a position where the president is encouraged to appoint only political appointees who are, independently wealthy and would be able to circumvent congressional fines?
That's a really good question, and I know it's something that Mort has been thinking about. I think it's important to remember when we're talking about this proposal that this isn't the only way to enforce a congressional subpoena. And so I think kind of some of the attention that we gave earlier to the other avenues may be better suited for those situations, but I will leave it to Mort to answer this question.
I agree, and that's why I've been enamored a bit by the analogous rights of judges to appoint private prosecutors. I don't know why. If that's valid, let's have that as a backup. Shaming used to be, a very effective device years ago when we were younger. A subpoena was something to be frightened of. A contempt citation or a potential prosecution even more frightening. We have to revive that, as well as using fines as an initial attempt at shaming. And yeah, that's a problem. People can pay these fines.
Well, I think you have to look at the fine as the process, not as, I represented the clerk of the House in a case in which the clerk was put into contempt for refusing to turn over documents in a Bivens lawsuit that was filed against the Aging Committee staff in the district court in Maryland. And the judge there fined the clerk $500 a day. Well, I went to Richmond and I got a stay in 5 minutes. So that was the end of the fine until we got to the merits in the Court of Appeals. So I guess the point is there's no way around that. What I think the impetus for this is not so much the fine, it's getting a resolution in a timely fashion by a court. How can that be done more efficiently and expeditiously than is currently being done in this case? I agree with Irv. You can't avoid the courts, and you shouldn't try, in a sense. Actually, what has caused some issues internally, I think, is the fear of getting a court ruling that doesn't vindicate the position of either the Congress or the President. So there's some reticence to get that ultimate resolution, because if you get the wrong answer, you're stuck with it.
All right. Thank you very much to our fabulous panelists. This has been a great discussion. We also appreciate your presence here and all the great work everyone in this room is doing. So thank you very much. And please say hello quickly before you leave, and let's be in touch in the future. Thank you.